right, a lot in the news tonight. Michael Jackson, Robert Kraft, and 3 trials we're covering here on the Law and Crime Network. First, the New York man convicted of killing a Queens jogger today learned that he'll spend life in prison without parole. This is how it looked when officers led 22-year-old Chanel Lewis off to prison. He confessed to viciously attacking Karina Vetrano while she was out jogging. But today he said he was innocent. The victim's mother called Lewis remorseless and a pathetic, evil coward who carried out the work of Satan. First, though, the victim's father.
My heart was ripped out of me that night, and it created a void that will never heal. Only my faith in God and my belief in heaven keeps me from killing myself for fear of not being allowed into heaven to see my baby again. Now, I would speak to you as a victim to a Supreme Court justice. Whatever happens here today, whatever sentence you impose, there will be no true justice. The light of my life was brutally beaten and murdered by that animal. True justice will be served only when he is dead and he meets the Lord our God. He and only he can impose true justice upon that murderer, and he will feel the wrath of God and burn in eternal hell. That convicted murdering rapist deserves to spend the rest of his life locked away from society. He's a serial killer in the making. If he wasn't caught, I know he would have killed again and again. He's proven that. As an angry, violent boy, he told a teacher he wanted to bring a knife to school and kill all the girls. As an angry, violent man, he made good on that threat the night he killed the brightest light in the world, my baby girl, Karina. After he had already killed, he searched on his phone how to forcibly rape someone. And again, that was after he had already killed and raped Karina. So his intentions are obvious. He wanted to kill and to rape again and again. And he will if he is ever let loose on this world. He has shown no remorse, no regret, and no sorrow. I ask you to use the power that was given to you by the people to protect the people that gave you that power. The only way to do that is to make sure he never has the opportunity to kill another innocent person.
Later, the victim's father said he felt compelled to deliver a message from the victim herself, implying that the connection between daughter and father stretched beyond the grave.
Karina has asked me to give you a message. Reluctantly, I will do so. Now remember, these are not my words. These are her words. She told me that if you stand up here today in court and ask for her forgiveness, tell her you're sorry, she will forgive you. But remember, those are not my words, and I will never forgive you.
Never happened, but now to the victim's mother, whose rebuke became harsher and harsher with each passing second.
This is Karina's day, and it's hers and hers alone. This is the day where we acknowledge that Karina's life matters. I want to show you. These are the shoes. These are Karina's shoes. These are the shoes that she put on the morning of August 2nd as she prepared to work and wore throughout the workday. As tiny as they are, Your Honor, these are the shoes of a giant, a valiant warrior, and a queen. The vacant expression you show is merely a reflection of your detached and empty soul. You've proven over and over again you are a very clever and capable man. Chanel Lewis. Contacting and complaining to news reporters, boasting about your front page notoriety, your phone searches, especially those made after you voluntarily submitted your DNA, are particularly revealing of your resourcefulness, knowing your secret would soon be exposed. The very second you laid your loathsome hand upon a child of God, my daughter, my innocent daughter, you rejected the Holy Spirit and carried out the work of Satan. The angels wept and the devils danced with delight as you proceeded to torture and impose the most brutal and merciless slaying of my beautiful baby. So repulsive are you that you left her hidden to be further desecrated in the summer heat by bugs and animals. Like a snake, you slithered away into the night with your secrets and your feculent wounded hand and your lies.
The defendant admitted detail after detail of this brutal attack, but you gotta hear this. This is where today he said he didn't do it.
One thing I want to say, Judge, is that I'm innocent. And I'm sorry for the family's loss, but I didn't do this.
Anything else? Anything else, Mr. Lewis?
No, sir. No, sir.
I hope you caught it there, but in case you didn't, let's listen to that just one more time and slow it down.
One thing I want to say, Judge, is that I'm innocent.
Right after the defendant uttered those words, his own attorney turned and rolled his eyes toward the judge. Why? Because the defense had just given a speech to the judge about why the judge should be kind to this 22-year-old without a prior arrest record. Former federal prosecutor and current criminal defense attorney Gene Rossi is with me tonight on this case. Gene, good to see you tonight. It's a bad look for an attorney to get caught rolling his eyes at his own client, but this defendant shot himself in the head by backtracking and saying, oh no, wait a minute, I didn't mean to confess. I didn't do it at all.
Well, a couple problems there. A defense attorney should always keep a poker face. That's number one. And number two, a defense attorney should always speak after the defendant for this obvious reason. And moreover, I would not have the defendant say anything. But if you are going to let the defendant say something, let him speak before you do, because you want to clean up for any mess.
And this was a mess that certainly would have been tough to clean up after. I mean, you've got the defendant saying that the vitriol coming out of the mother. Look, these sentencing hearings, oftentimes when you put a microphone in front of family members who've been building up and building up and building up with all kinds of emotion, grief, anger, it erupts in these hearings, and that's what happened in this one.
Yes, I think the defendant should say a prayer that he is not in the state of Texas.
Oh, exactly. I mean, or any state with capital punishment, because this probably would have been a death sentence.
Oh, absolutely. Not even close.
All right, Gene Rossi, we're going to be back to you as the broadcast rolls along here tonight. We'll wrap that sentencing up. Jury selection slowly progressing, though, in the trial of a Georgia woman accused of starving her stepdaughter to death. Tiffany Moss is charged in connection with the death of her 10-year-old stepdaughter, Imani Moss, and for burning the girl's dead body to try and hide the evidence. Prosecutors say she took care of her own children but neglected Imani. Moss is taking her life into her own hands by representing herself in her own death penalty case. Law&Crime's Vincent Hill has been in the courtroom for jury selection and discussed the case earlier today on the network.
Just in front of me is the apartment where little Imani was living, and directly behind me is where investigators found her body on that fateful day many, many years ago. So I was in the courtroom earlier this morning. We thought that they were about to start striking the jury. Unfortunately, one juror was about 45 minutes late. There were 4 jurors that actually were not responding to phone calls. So, of course, the state wanted to wait for those jurors to show up. They recessed until 1:30 this afternoon, where they will begin striking that jury at that time. We want to know who is Tiffany actually going to call as a witness. We suspect that her mother will be called as a witness. From what I understand from talking to the deputies inside the courtroom, her mother will be in the courtroom tomorrow. So maybe she will call her as a witness, maybe more on the lines of a character witness. We understand that she also filed this lawsuit against Child Protective Services here in the state of Georgia. So maybe she's going to use that as part of her defense to say, hey, listen, this was reported to you guys before. Now here we are. You guys didn't act. I've been in the courtroom since Friday, and every day she's walked in, dressed not in a jumpsuit. You can see her there on your screen, but she's dressed in casual clothes. She comes in like she's an attorney. She has her notebooks. She has some law books with her. She isn't really communicating with the defense counsel that's seated behind her. The judge asked if she has any objections to any of the jurors. She's always said, no, Your Honor, I have no objection to this juror. So she really hasn't been consulting with that defense team that is still, required to be in the courtroom with her. So she's really essentially acting on her own behalf.
Gene Rossi joining me one more time to talk about this case. Gene, we're waiting for things to get going in this. We're waiting for these opening statements to happen. But this defendant representing herself, a lot of people are saying, oh, only somebody with mental health issues would represent herself when her life is on the line. I don't necessarily see as big of an appeal issue as some people do with this case because, look, maybe she does represent herself and maybe she asks good questions and maybe she indicates that she's got it more together than people think.
Absolutely. And as long as that judge held a proper Feretta hearing, which is that Supreme Court case to determine whether that defendant is making the right call. The other thing that I want to say is her representing herself could backfire big, not just on evidence and presenting your case and defending and cross, but the prosecution's theory is that she was sort of the mastermind of this murder and that the husband sort of acquiesced towards her because she was sort of the brain behind the operation, and her representing herself and showing a relative competence, that's going to feed into the prosecution's theory that she, in fact, is this killer.
Yeah, that's an interesting insight as well that I hadn't thought of, Gene. So, you've got that element of it, but I also looked at it from a theatric standpoint. Okay, trial advocacy would be the more proper word for it. Maybe by acting as her own counsel, she gets to say a lot of things to the jury without sitting in the defendant's chair, and that's really interesting.
Well, I've seen a lot of pro se people that represent themselves, and if you have a really good judge, Aaron, when that pro se defendant goes off the reservation and starts saying crazy stuff, you're going to see a good judge will just interrupt them and embarrass the heck out of them in front of the jury, and it ends up backfiring. And I've seen a pro se eventually say, you know what, I'm going to let the real attorneys take over because I'm making a fool out of myself.
I've seen that before too, Gene. We're going to have to wait and see how this case rolls along. We'll see you at the end of the broadcast. Yet another arrest in a Florida sex trafficking sting which nabbed Patriots owner Robert Kraft earlier this year. Police have arrested Shen Mingbi for allegedly performing a sexual act on Kraft in January. Authorities say they caught the act on surveillance video, which shows that another woman was also involved in the act. A judge has temporarily blocked the release of the video in question. Kraft's legal team argued that releasing the video violates his right to a fair trial. Kraft is charged with soliciting another to commit prostitution, but has pleaded not guilty. Still ahead tonight on the Daily Debrief, a former attorney for the King of Pop, Michael Jackson, is finally responding to new claims that the late singer abused children. Plus, a defense expert is under attack by the state in the case of a California man accused of murdering a family of 4. We will head back inside the courtroom after this break. An attorney for late singer Michael Jackson sat down for his first interview with Law&Crime and our sister site Mediaite since explosive accusations came out in an HBO film. Attorney Tom Mesereau is joining the cast of Jackson Associates who are critical of the film Leaving Neverland, which claims Michael Jackson perpetrated years of child sexual abuse. Mesereau looked back at Jackson's original trial and said one of the key subjects who levied new accusations against Jackson has serious credibility issues. During Jackson's 2005 trial, Mesereau says accuser Wade Robson was telling the truth when he testified Jackson did nothing. Now Mesereau says Robson is lying.
But all I know is I spoke to him for hours. He testified on the stand. It was the most watched trial of my lifetime. You had more accredited media from around the world than O.J. Simpson and Scott Peterson combined. And he was in the spotlight in that courtroom and subjected to withering, persistent, skilled, professional, experienced cross-examination, and he was adamant that Michael Jackson had not improperly treated him. All I know is the person that I spoke to, the person who I call as a witness, and there's no doubt in my mind he was telling the truth.
Mesereau says he is no longer making money representing Jackson's interests. Others who are have written letters complaining about the film's journalistic integrity. Mesereau's entire interview is up on lawandcrime.com. Now to the McStay family murders in California. Defendant Charles Merritt, he goes by Chase, is accused of killing his business associate Joseph McStay and the entire McStay family. The family disappeared in 2010, and authorities stopped looking for clues after they presumed the family had vanished into Mexico. Years later, however, the graves of all four of the McStays turned up in the Mojave Desert. Defense tests on 2 items found buried with the McStay family in shallow graves revealed the DNA profiles of 3 unknown people. The unknown profiles came from a rope tied around Joseph McStay's neck and from Summer McStay's bra, which had been cut presumably by her attacker or attackers. The unknown profiles are from none of the McStays and are not from defendant Chase Merritt. Who are they from, and are the profiles from the real killers? And why did the defense have to perform their own tests on these items after tests by the state failed to yield these clues? The defense is naming another man as the person responsible for these killings. Dan Kavanaugh claimed to have been in Hawaii when the McStays disappeared, but defense forensics experts say that might not be true. Someone accessed Kavanaugh's PayPal account from a Hawaii IP address on January 14th. The account, however, was accessed from Southern California January 26th through February 14th. The family disappeared in the middle of that around February 4th. The account was not accessed from outside Southern California again until April, when it was accessed from Washington State. A defense expert yesterday pushed back at police claims that they might have seen blood on a table at the McStay home, but never collected it. And the expert counteracted the prosecution's theory that the McStays were killed in their home. Here is how prosecutors cut back into that defense expert's conclusions. The state is now suggesting that the children were killed somewhere that was easy to clean up, a bathtub.
Okay, so a massive cleanup effort. You are aware that there, other than a diaper, there was no children's clothing found in the graves, right?
Objection assumes facts, not in evidence.
I don't recall, but if there were children's clothing from the gravesite or not.
Isn't that important to determine if something happened in the house or not?
Objection argumentative.
It's not, as far as something happening in the house, I'm not sure I understand the importance of that.
Well, let me show you exhibit number, what is this? 109. 109. Did you view that photograph? Can you zoom in?
Yes, I did.
Okay. What's on the floor there?
Clothing.
What kind of clothing?
Looks like potentially children's clothing.
And what's directly across to the right, if you zoom out, what's directly across from there?
A closet.
A bathtub? Directly to the right of the clothing? Off camera?
Objection calls for speculation.
Did you review the diagrams in this case of the home?
I did.
Okay. On the master bathroom, is there a bathtub directly across from the sink?
I can review that diagram if you like.
Other than a diaper, there's no other children's clothing found in the graves.
Objection assumes facts, not in evidence.
Right?
That certainly may be the case.
Okay.
And objection speculation is the answer.
And there was children's clothing here, which would be under master bathroom on this diagram, which is exhibit. We'll get it. There was children's clothing there, right?
Appeared to be children's clothing on the floor of the master bathroom.
Okay. Would cleanup of killing children in a bathtub be easier than on a carpet?
Your Honor, now this is argumentative. This is closing argument of a made-up story without evidence.
Objection,
Now-
sustained, assuming facts not in evidence.
And I would like to approach on all this.
Denied.
Gene Rossi joins me one more time here on the debrief. So, Gene, the judge overruled a ton of objections to speculation there. The state is saying that because there are children's clothes on the floor of a bathroom, that must mean that the children were murdered in the bathtub and that the evidence was just washed down the drain. What do you make of that one?
This is the second time today I've heard this, and I'm going to show some energy. I have no clue what dots this prosecutor is trying to connect. I honest to God, have no idea what he's trying to prove. And furthermore, if those children were killed in the bathtub, you would have blood all over the place. My goodness gracious.
Yeah, they're saying that they weren't saying they were drowned. They're saying their heads were bashed in with a hammer. You know, I mean, so what is it here? Is this a case of a prosecutor just trying to fish for some reason to try to tie this guy to something?
Yes, and here's why, Aaron. Because if they can't show venue, that the murders occurred in that home in that county, then if there's a jury instruction on venue, the jury's going to find that the murder occurred somewhere else in the Mojave Desert. They're trying to put a square peg in a round hole. I don't understand it.
Okay, objections there at the tail end saying, hey, look, this is a made-up story. This prosecutor is trying to do closing arguments with facts that are not into evidence. The judge didn't want to approach, and the judge is basically shutting down a lot of these objections.
Well, I got to tell you, sometimes when a judge is overruling objections of the defense overly in favor of the prosecution, that can backfire on the government.
Oh, it
really
can. It can. I agree, Gene. We're just about out of time. Appreciate you joining us. Great insight tonight. We'll see you back here tomorrow, folks, at 5 o'clock Eastern here on The Debrief for another recap of the day's events.